And I'm very glad to have our two speakers joining us today, Tim Pohlmann, the CEO of LexisNexis IPlytics, and Vivian Wang, the License Director at Purplevine IP. Hello, Tim and Vivian.
Hello, Eren. Good to meet you.
Hello, Eren.
Okay. And before we dive into today's discussion, I'd like to take a few moments to learn more about our speakers. So I'd like to start with you, Tim. So would you please tell us more about yourself, your professional journey, and more about IPlytics?
Sure, Eren. Thanks for having me here. My name is Tim Pohlmann. I founded a company that many know as IPlytics about 10 years ago. The company's purpose is gathering data on patents and standards and find connections of patents to standards. Analyzing the world of technologies like 4G, 5G, Wi-Fi 4, 5, and 6, video codecs, but also beyond that, audio codec and other standardized technologies that relate to patents. And IPlytics is a software that basically gathers the data and analyzes it. 2 years ago, we became acquired by LexisNexis, so that is why today IPlytics is part of the LexisNexis group, which of course has other solutions as well. And I remained there to take over the business of SEP tools in the LexisNexis suite.
Great, very good. So I'd also love to invite Vivian to do an introduction to yourself and Purplevine IP.
Yeah, certainly. First, I go to Purplevine. Yeah, Purplevine is a global IP service provider founded in Shenzhen, China. Currently, we have over 10 offices and around 450 employees worldwide. Our company offers a wide range of services, including global prosecution, analysis and consultation, investment, transaction, license and enforcement, dispute resolution. So basically, we provide our clients with comprehensive and innovative solutions for all their IP needs. Me currently serve as a global licensing director at Purplevine. With the team, we assist our clients with their licensing negotiations. Before joining Purplevine, I spent nearly 14 years working in-house at ZTE, where I was responsible for managing the overseas litigation and the licensing team. Thanks for having me here.
Thank you. That's very impressive. Okay, so today's topic is about SEPs and licensing in China. So when we talk about SEPs and the licensing negotiations, one important part of it is understanding SEPs and the SEP data. So how many patents are being licensed, who are the major SEP holders, and who are likely to request royalties from the implementers. So with all these questions, I think Tim today will first provide his insights on how we can use SEP data in the FRAND license negotiation. So over to you, Tim.
Thank you, Eren. And I will now show a few slides and walk you through it, how we help with data in basically facilitating licensing. And that is the idea of IPlytics. We're helping, just to confirm that to everyone, both sides of the table. We have many SEP holder customers, but we have equally many customers in the implementer space. Can you see my screen and my slides?
Yes, very clear.
Very good. Great. I think to start with, I want to just make everyone aware that the world of standardization is very complex. And that is also why the data is very complex. Standards are not set and then are final. Standards are evolving, right? And every month, I think these standard bodies meet and there's different releases that are set, even though there's 5G now since a couple of years, but they're different versions of 5G, right? And if you have a phone today, the version of 5G is different than the next generation's phone. These standards come in generations. These are the biggest changes in technology. But also within the generations, we see different protocols. And these different protocols serve different purposes, right? If you think about your phone and you make a video call or an audio call, that video and audio function is not needed by an IoT device. An IoT device sends a signal of information to some other device, maybe once an hour, but there's no video and audio. So you can imagine that not all 4G and 5G is used in some of the IoT application. So you need to look at particular protocols that are sometimes both 4G and 5G, like NB-IoT or LTE-M or Cat1. V2X is a particular one for cars. And then you have to differentiate between IoT devices, consumer devices, but also the infrastructure, which is base station. So when we talk about 4G and 5G today, these are just big technology projects which have a lot of technology that we have to differentiate to underneath. And that's, I think, an understanding I want to start with. The company IPlytics was founded because the world of global patent data and the world of global standards data is pretty much divorced, right? There's no link between those, and the databases are often incomplete. Everyone probably knows about a database that ETSI provides for 4G and 5G patents, which is a very complete database, although a lot of those patents are not tested to be essential. But if you think about Wi-Fi, 92% of the patent owners in Wi-Fi do not make public their patents. The same is true for video codec and audio codec or Qi wireless charging. So a lot of patent data is actually missing, right? And even though we have patent lack of ETSI, this is disconnected from a lot of other information you need, like ownership, legal status of these patents. And last but not least, the biggest challenge, I would say, is that there is no public information whether or not a patent is essential, right? And all these, I would say, transparency issues is what we try to address with IPlytics. If you think about a standards implementer, right, we get a lot of questions from standards implementers that enter the market. And especially in IoT, we see a lot of companies that are new to it in the automotive space, but also in the smart meter space or in other spaces where something connects to a cellular device. Those companies ask us, hey, which standards implemented our products are actually subject to SEPs, right? Are we infringing? And who are the owners of these SEPs? Do I know all the owners, right? Did I see them all? And last but not least, the most important question to anyone implementing the technology is, okay, I understand this is a patented technology, but how much do we have to pay? And there's no answer to it, right? There's no answer what the aggregate royalty is. Basically, the royalty you have to pay, if you sum up the royalties that all these different actors in the world are going to ask you for money, right? There's not just one company. There's not just one pool. And that is a very challenging situation. I want to give you an example from the video codec space. Many of our customers that have devices like screens or video implementation of technology, this could be virtual reality devices, this could be streaming, this could be anything where videos are used. And those get what we call love letters, right? Patent pools or patent owners send them a letter and saying, hey, you're using our standardized technology and you have to pay 40 cents per unit, right? And that is an actual real case. Because one of the HVC pools, HVC Advanced, is asking for 40 cents per unit. There's another pool for the same standard, HVC VLA, that is asking for 20 cents, right? And the good thing about patent pools is that that data is openly available. I included the links here in the slides. But still, even if you have an offer with a price and you know the patent pool, which actually gathers different patent owners together, the big question remains, what percentage of the HEVC patents are covered by the pool? And you can ask the same question for any other standard. What percentage of Wi-Fi patents are covered by a pool? What percentage of cellular 4G, 5G patents are covered by a pool? Again, that data is not publicly available. Which patent owners or SEP owners are part of the pool and which are outside? And who owns how many of the patents? Again, that data is not publicly known. Patent pools basically list those members, but who is outside of the pool? How do you know that, right? And of course, patents are dynamic. Patents, especially when they're standard essential, are very often sold to so-called patent trolls or patent assertion entities. Do you know those companies? They're typically very small, they have weird names, and they suddenly own larger portfolios of patents that you have not been aware of. And they may very be aggressive approaching you and ask for royalties. But going back to our example, we have two patent pools, one asking for 40 cents, one asking for 20 cents. So you as an implementer would say, I know something here. I know that I have to pay 60 cents if I pay both pools. But again, what is the share? How many patents are covered when I pay off these pools? Who is outside of the pool? Who are known licensors and who are the unknown licensors? And at IPlytics, our goal is really to basically put data behind all these question marks in these squares that you see here. And this is what we do at IPlytics. We have basically created a database that gives you access to all these different standards. These can be cellular standards, 3G, 4G, 5G, video standards, AVC, HEVC, VVC, AV1, VP9, different Wi-Fi generations from 4 to 7, different audio generations and audio codecs, wireless power, but also IoT protocols like NB-IoT, LTE-M, and Cat1, and broadcasting. And we provide data where data is missing, right? Where data is not declared publicly. We have an AI that can identify patents that relate to a standard, and we have another AI that would at least score these patents into their relevance, how likely essential they are to the standard, which gives everyone a very transparent database. And again, we work with the SEP holders and the implementers in the same way, right? Maybe to matchmake and try to identify common grounds. And I want to just give you one simple example to show you how the data can also help you to come in the end to some price point. Because in any negotiation, we have a situation of understanding what we call the numerator. What does the patent owner own, or the patent pool? And the denominator, what is the total stack of patents worldwide? That information is key to understand, how expensive and what the aggregate royalty is and how expensive it would be to pay off everyone, right? And this is what we did for the HEVC advanced example. This is a screenshot of IPlytics, and you can see the share and the number of patents of the two pools that are covered, right? And the two pools together cover 52.12% of the total patents of HEVC. So we did, fill in information to one of the questions and question marks in this picture, right? So now if you would pay for HEVC, those two pools, you would cover 52% of the patents. And again, this is the example of video codec. You can look at this for Wi-Fi. You can look at this for cellular, 4G, 5G. You can look at that for many standards. But we can also fill data into the other question marks. Because the big question is, of course, now I know how much I have to pay for the pool. Doesn't that price point, if I also know the share of the pool, give me the possibility to calculate the aggregate royalty, the total royalty if I would pay every SEP owner, right? And again, for the example of HEVC, I want to show you that two pools for 60 cents covering 52% gives you a very actually simple equation. You just take the share of the pool and the royalty they asked for to extrapolate that to an aggregate royalty. And as you can see, if you almost cover a little bit more than 50% and you pay 60 cents for both pools, obviously that means we come up at something close to 1.2 cents, right? And if you calculate that precisely, we arrive at 1.115 cents per device, right? Based on the pool rate. Let's say the pool rate is our reference point, we can estimate that the total aggregate royalty for all HEVC worldwide SEPs to be compliant to your product is $1.15. So any product you sell, $1.15 goes to a SEP owner. That's the maximum, right? Based on the pool. And we put those numbers in the question marks. Now we have a full picture. We have data for the HEVC standard. And again, we can do that for VVC as well. We can do that for audio codec, Wi-Fi, and cellular, right, to arrive at these total. But we can also look at now pool outsiders, right? Very many significant companies that heavily license their patents are outsiders. Just to name them, Qualcomm, InterDigital, MediaTek, Nokia, Ericsson, but also a patent assertion entity called Key Patent Innovators. Those are companies that are not in the pool of HEVC, but outside. And also here we can calculate their share. And we can calculate if the pool asked in total for 60 cents, we can calculate, and the total aggregate royalty therefore is $1.15. We can calculate what each patent owner based on the rate would ask, right? Qualcomm would in that case ask for 10 cents, 0.8, right? But the question is, what happens if Qualcomm is asking for 30 cents, right? That to this equation would be excessive. And that is exactly why data helps. If you get approached by companies like Qualcomm, InterDigital, Nokia, Ericsson, MediaTek, you want to know, is the rate they're asking me, is that a reasonable rate or is that excessive, right? And for that, you need data. If you think about the pool rate as a reference point, I think for the case of HEVC, it is a pretty good reference point. I'm an economist, and I would say a price in the market is a good reference point when it is market accepted. Now look at the both pools. One pool gathers 42 licensors, the other one 47. Again, that is more than 50% of the market. Look at the licensees. HEV Advance has over 300, almost 350 licensees. HEV's VLA has almost 450 licensees. This is a huge part of the market. I would say, if you think about that, over 40 licensors make deals with over 400 licensees. Having so many deals, think about it, is a good reference point. It's market accepted. People have paid the pools, and we can say the 40 cents and the 20 cents are in that way somehow a good reference point. I'm not saying you cannot argue they're not reasonable. You can still challenge the price, but it is an accepted market point, so it's a good price point to compare with, right? However, there are other opinions in the market, right? Patent pools cannot set the price, right? There are other reference points that you can consider. And there are, in fact, economic studies that identify aggregate royalties based on a different approach, based on how much value does the standard give to the product. And there is one that is actually coming from a consulting firm, Edgeworth Economics and Shepherd Mullen, and they find for HEVC only a total aggregate royalty of 28 cents per unit. Again, if we would take the pool price, which is already 60 cents, and the share of 52 and extrapolate it, we arrive at $1.15. However, that economic study only arrives at 0.28, 28 cents per unit. So that is much lower, right? That is very, very much lower. That is less than 1/4 of it. Now let's take that study as a reference point, and you see that companies like Qualcomm, they cannot ask for 10 cents anymore. They can only ask for 2 cents, right? So depending on what reference point you're taking, using our data to extrapolate it, you can calculate how much all these pool outsiders, but in this case also pool insiders, can ask for you. And the economic study is very much in favor of implementers. So that study may be a reference point that you want to use or start with. And that reference point also allows you, of course, to challenge the pool price, because as to the economic study, the pools are overpricing, right? So you can see that, in fact, HEV Advanced should only ask for 13 cents and VLA only for 6 cents, right? So if you want to challenge the pool rates, that's also possible. You have economic studies out there, but you need to have data on patents to extrapolate from the total aggregate royalty down to each patent pool's royalty asked and each patent owner's asked. And we give you the data to put money numbers behind it, right? That's really what we do. We can do the same for Wi-Fi. I don't want to go through all the details as I did for HEVC, just to show you that it's also possible. In Wi-Fi, we arrive at a much higher rate. It's almost over $3 per unit. We actually have a Wi-Fi 6 report just published yesterday. Everyone interested in the data, the report is published. And we can put numbers in behind Wi-Fi as well and come up with an aggregate royalty here, pool outsider, insider percentages and prices. And also here, there's a Wi-Fi economic study that comes up with a much lower rate, which is between only 4 cents and 69 cents. That's a study by the Battle Group. And again, that would calculate to much lower rates, right? I think what is important, and that's my final slide here, guys, is that if you are in a FRAND negotiation and someone approaches you for a license, it is very important to understand if the offer you receive is excessive, right? And data gives you a reference point, right? It may give you different data points. You cannot think of a FRAND rate as one price that is correct, that is the truth. FRAND is always a range. And we at IPlytics help you with calculating different reference point of price points that allow you to say, hey, taking an economic study is this price point. Using the pool rate as a reference is this price point. But you, dear patent holder, you're asking me for a much, much higher price that is far from other reference points, right? That is unreasonable. And you need, on your side, data, objective data to make the case, right? And other reference points come from pools and economic studies, but there are also FRAND rules now. We have in the UK different decisions on what a FRAND rate is. And those decisions also allow you to say, well, as to the U-Court ruling, which is a global FRAND rate for a particular patent owner, this is the rate per patent that was calculated, right? You're asking me for 10 times that, right? So that's a very objective way with data to counter-argue against excessive data. However, I can tell you that also SEP owners use IPlytics for the same reason. A patent pool uses our data to show that they have a huge coverage of the patents, that a lot of the patents are covered when you sign with them because that data is not public, right? And the IPlytics data is neutral because we work for both sides of the table, the SEP owners, but equally for the implementers. What is the goal of IPlytics? What is our vision? What is our mission? We really want to help both sides, the licensor and the licensee, same as patent pools, to reduce the time to negotiate, to have a starting point that is objective, right? If you think about the implementer, I think the information they have is lower than the patent holder. So having access to data is very important to really identify and understand the value and the share of patent portfolios in the market, and then prepare for FRAND negotiation with a price point, with understanding of how much the other side is actually allowed to ask based on different reference points. But even if no one has been approaching you yet, or even if no one is litigating you, knowing a price, having an aggregate royalty, even if it's arranged, even if it's not one price, mitigates risk. You as an IP professional can go to your financial department and already plan in how much you're probably asked to pay, right? And the world is dynamic, right? Ownership changes, litigation is coming up. Tracking data behind it is really important, right? If a patent assertion entity acquires a larger part of a portfolio, you want to know about it. If a litigation happens in the US, Europe, or China that is about SEPs, maybe SEPs in your market, maybe one of your competitors is the defendant, you want to know about it, right? You want to track that information, and we give you the data to do that, and we help with that. So that was my slides, and I hope I was able to give you a good overview about how to use data in a FRAND negotiation and how it's helpful as a starting point. I'm not saying data will always close the deal or basically resolve the issues and challenges, but it's a starting point, and we can at least resolve the transparency challenge that we see.
Thank you, Dean. Thank you for the very insightful presentations. And I fully agree that standard and SEPs is a complex word, and understanding SEPs and the portfolios is a very important starting point for FRAND license negotiation, especially for the companies, Chinese companies that are quite new to license. So it brings to my next question. So I would like to ask Vivian. So how do you see the SEP licensing development in China nowadays?
Yeah, before I go to my question, yeah, I'd like to thank you, Tim's share. Yeah, SP data is complex, and for companies, I think involve SP matter to understand thoroughly about those SP data is quite crucial. So yeah, it's no doubt we can see IPlytics can be quite useful for these companies to get its SP data. Yeah, so thank you, Tim's share. Yeah, go to my question when talking about the SP licensing. I think the SP licensing is pretty familiar territory for us now, even in China, especially in those telecom and electronics sectors. When I was at ZTE, I was involved in the Huawei versus ZTE case across several European countries, which led to the European Court of Justice establishing the FRAND framework for SP licensing. Even with more and more new case laws emerging from different jurisdictions, the ECG guidelines remain the main framework for SP licensing. And nowadays, we still can say patents related to cellular and codec standards are still major topics for licensing. In China, SEP licensing is becoming increasingly active. On one hand, with the rise of new innovations and technologies, especially IoT advancements, more industries and companies are becoming new licensees. On the other hand, companies like Huawei, ZTE, among others, which were primarily licensees before, are now actively licensing out their own patents. We also see that China is clearly committed to fostering innovation, and this includes actively regulate SP licensing practices through both judicial and administrative measures. It's no doubt the country is taking significant steps to ensure that SP licensing is managed effectively and equitably.
Thank you. Thank you, Vivian. And I also have a question for Tim. So when we talk about SEP portfolios and the declarations to the standardization organizations, I know we still have many challenges. For example, the so-called over-declaration, companies are declaring their patents at a very early stage for those patents that are likely to be essential. And also for some technologies like HEVC, VVC, and Wi-Fi, we don't have like a public database. So those SEPs are hidden under the so-called blanket declarations. So how do you see these challenges in SEPs, and where could we find the solutions?
Yes, I think you hit exactly the two main data challenges that we have, Eren. I think that is not mentioned enough that one source of information beyond patent declarations, which are either incomplete or don't have information on essentiality, is also patent pools. Patent pools often publish lists of third-party evaluated patents that are claim charted. And for some of the standards, like in video codec, we at least have a starting point with patent pool data, right? HEVC, as I showed in my slides, the pools cover more than 50%. That means more than 50% of the actual SEPs are publicly listed on the website, right? So that is appreciated, that pools, provide not only a license and a one-stop shop, but also data, right? I'm a data person, so from the data perspective, that is great. But indeed, there are challenges, and it's unfortunate that we don't have more data. And of course, that is what we do at IPlytics. We help with adding data to the public to kind of fill the gaps, right? One we call undeclared patents, as you say, declarations hidden under blankets. What does it mean? A company makes a declaration, we own patents, but we're not going to tell you which one. So is it one patent or is it 1,000 patents? We don't know that, right? And which patents? Is it a patent in China or in the US? All that information isn't public, right? And what we do with an AI algorithm, we identify those patents that are missing in the public domain for video codecs, AVC, HEVC, VVC, AV1, VP9, for Wi-Fi generation, for audio codec, for Qi wireless charging. AI is not yet perfect. I'm not saying we identify only essential patents, but we identify patents that relate to the standard. And that gives you an understanding who are the major owners, right? If you think about a market overview, we can give you an overview. Who are the strongest owners and what is the share that the pool actually covers, right? The second question is even more challenging. Which of these patents are really essential, right? I keep providing the example just recently, the German court and the UPC looked at the very same Qi, potentially SEP, right? The German court said, well, the patent in question is infringing, meaning essential for the Qi standard. And courts, the way they work, they get claim charts, expert testimony, product managers, R&D managers, lawyers. They all get a lot of information on just one single patent. UPC decided the patent is not infringing, is not essential. Two courts come to different conclusions. That shows how complex it is to identify a patent to be essential or not. At IPlytics, we have, again, another AI to score and relate claims to sections. Each claim section combination is scored, and we give you the likelihood of how likely the patent is essential. Again, it's not perfect, but allows you at least to identify, as you say, over declaration, identify those patents that are really unrelated. It is a very fast way to clean the database and cut out the unrelated. There's still patents that are essential or some are not or partly essential. We cannot make it perfectly, but we can at least filter away and we can score, right? So that means we can look at the average score of a particular company and their portfolio. And if it's higher, maybe they have a more likely essential portfolio. Again, we cannot give you this specific number, but we can use AI to get closer and to kind of close some of the transparency gaps that we have.
Yeah, thank you. Yeah, I fully agree that with the development of the technologies, more and more standards and SEPs are being licensed. When it comes to those newly emerging industries like IoT industries, those are really challenges for the smaller size companies. So I would like to come back to Vivian. From your experiences in China, what are the major challenges that Chinese companies are facing in licensing nowadays, especially for those like IoT companies?
Yeah. We will notice that with the advancement of IoT, SP licensing has expanded into numerous new sectors such as vehicles, EV chargers, medical devices, smart meters, etc. Essentially anything that requires connectivity. Lots of these companies might not really know much about SP licensing stuff. On one hand, they need to manage their current licensing activities carefully. On the other hand, they should also focus on their long-term strategy, moving from a passive stance to a more proactive role in the global market. Because SP licensing, we all know, is a global endeavor and involves active participation in international business activities. IoT devices often need to comply with multiple global standards. Also, like Tim also mentioned, those standards are evolving. And so navigating these licensing requirements for the standards can be very complex. This would require substantial resources and expertise to navigate complex negotiations to make sure these companies are meeting FRAND obligations while protecting their own interests. So with the fast pace of innovation in IoT means that technology and standards are evolving quickly. So I think keeping up with these changes and adapting licensing strategy accordingly can be a huge, significant challenge.
Thank you. Tim, do you have any comments on this topic?
Yes, I think one thing to appreciate is that I think China is on the forefront of IoT. I think compared to the Europe region or US region, connectivity, especially in IoT, advanced much more in China than in the other regions. And I think, as Vivian correctly said, in order to remain that advantage, those companies, those new players in IoT, should also think about having a seat at the table. Standardization is open. There are particular groups in, for example, cellular standardization in 4G, 5G that relate to IoT connectivity. So why only implement the standard? Also be there when the standards are developed. One thing we also, by the way, do at IPlytics, we track participation in those meetings and the contribution to the meetings. That's something that I would always recommend any IoT player. And I would also recommend to think about FRAND licensing not only as some aggressive SEP holders chasing you for money. It is really a corporation. If you look at very experienced implementers, and there are many also in China, think about the Xiaomi's, Oppos, Vivos, the smartphone makers, they have gone through this the past 10 years, and they're really professional now, right? They close a lot of global deals, but you have to become friends or at least partners with these SEP holders. You have to meet them in negotiation and global meetings. You have to be open to that. Because if you do that, you can do good business, right? And those companies did good business. Some of these companies also acquired patents from these other companies to kind of get more level playing field. So that is a game that you have to start being part of to make successful deal making. Because in the end, we are in a world of deal making. And deal making goes to people business, right? And that's something you have to understand. It's not your side, our legal representation, your legal representation. I think, and that's also why, you know, Vivian, your business is very important to be a consultant in the space, a matchmaker to explain how these processes work. And I think that's something I would recommend to IoT to do and to be open to.
Mhm.
Yeah, I like the word you use. We work as a matchmaker to facilitate this deal making. Okay, very good. Yeah, and one topic I'd like to mention is about AI, which is a very hot topic discussed these days. And how do you see AI will assist SAP licensing? And what is your comments on this, Vivian?
Oh, yeah. Yeah, AI is a hot topic right now, and Tim already just give us some brief introduction about AI implementation from IPlytics. But when it comes to SP licensing, because we all know that the SP licensing process involves technical analysis, royalty calculation, and extensive correspondence and negotiation. So which ultimately you have to project a licensing strategy aligning with your own business objectives. So specifically when it goes to details like determining whether licensing terms are FRAND often depends on the behavior of both parties involved. So in this regard, my view is that since human behaviors are involved a lot, I think the current AI tools have very limited utility. But I do think a good AI tool can make a significant assistance on patent analysis and valuation assessment. For instance, AI can help us with SB essentiality checks and conduct SB counting within specific fields. So I think Tim can give us more insights about this.
Yeah, happy to. I think you said a lot of good things, Vivian. I think we have to say AI is a great opportunity, but we are here in very complex negotiation, and AI is at the starting point, right? Our customers, when we present them our AI solution, they want to know the details. They do not accept a black box that spits out a number. That is not acceptable. That's not what we want to trust because it's complex. If two courts, right, very intelligent people come to two different conclusions, why would AI have the truth, right? And of course, it all matters of how the AI is trained. So when we go to customers, we are very open with this is the training data, right? We try to be objective in the training data. We try to be unbiased, but there's still potential for it, right? And this is the outcome. And this is how the AI takes the training data and comes to a conclusion. Explaining that as transparent as possible is the only way to have AI being accepted even in the process, right? And that is something very important. AI is something that, you know, if you want to use it in a complex negotiation, both parties have to accept as being neutral and objective. And I think people talk about accuracy a lot, but I think in our industry, it's not about accuracy, it's about bias. Is it an unbiased, objective tool that we can use? If not, if it's biased, if it's right favoring one party over the other, no one will use it, right? Because we are in a negotiation. So that is, I think, an important point that we all work very hard towards to make AI part of it. But that needs transparency, that needs great training data, and that needs unbiased, objective information, right? So that will be my 2 cents to comment on this one.
Very good. Thank you. Thank you, team. Thank you, Vivian. All right, so I think that's all of our discussions for today. So that's very fruitful and insightful. And thank you for joining us today. And hopefully we can have this virtual webinar more often or on a regular basis to discuss the development in China particularly. Okay.
Very good, Eren. Thank you for having us.
Yeah, thank you.
Thank you.
Great, guys. I think I can stop the recording. Good. I think that was a great session.
That was nice